The black box did not show panic. It showed the accelerator down, the throttle open, and no brake in the last seconds before impact. 2 young men were dead, Dominic Russo and Davion Flanagan. Mackenzie Shirilla survived. At first, this looked like a nightmare crash on a quiet road in Strongsville, Ohio. A teenage driver, a Toyota Camry, a brick building, a speed no one should have reached there. But then investigators found a problem with the word accident. The car was not slowing down, and the court would later hear one sentence from before the crash that changed the way the whole case felt. A sentence about wrecking the car. Hold that line. Because the case was not decided by one emotional moment. It was decided by 4.6 seconds. July 31st, 2022. About 5:30 in the morning. A Toyota Camry drove from Pearl Road toward Progress Drive in Strongsville. Inside were 3 teenagers, Mackenzie Shirilla driving, Dominic Russo in the passenger area, and Davion Flanagan also in the car. The road should have made speed feel impossible. Industrial buildings, a turn, a driveway, a building ahead, but the car kept gaining. Court records describe the Camry leaving the roadway and striking the company building. Dominic Russo and Davion Flanagan died from blunt force injuries. Shirilla lived, badly injured. That was the first public shape of the story, a crash. And there was a reason that word stuck at first. A crash can happen because of a blown tire, a medical episode, a steering failure, a mistake at the worst possible second. The early question was simple: what made the car do that? The answer started inside the car's own data trail. Investigators did not have to guess what the Camry was doing in those final seconds. The event data recorder gave them the part of the story a person can forget, deny, or explain away. According to the appellate opinion, crash testimony described the accelerator as fully depressed 4.6 seconds before impact. The throttle was at 100% until about 1.6 seconds before the crash. No brake. That matters because a panic crash usually leaves a fight in the data. A lift off the gas, a brake input, a correction, something. This data trail, prosecutors argued, showed acceleration into the impact. The speed figure was roughly 97 miles per hour before the car left the roadway. The prosecutor's office summarized it as a 100-mile-per-hour crash. That number is the headline. But the smaller number is worse. 4.6 seconds. At that speed, 4 seconds is not a blink. It is distance. It is time for the car to announce what it is doing. It is time for the body to react if something is wrong. And the black box said, the brake never came. But a black box still cannot tell you intent by itself. It can tell you what the car did. It cannot tell you what the driver meant. That is where the case got harder. Because the defense did not have to prove a perfect different story. They had to make the judge see reasonable doubt. Maybe a medical event happened. Maybe the driver lost control. Maybe something in the car failed. The appellate opinion shows those questions were tested. A mechanical expert found no pre-crash mechanical or electrical failure that explained acceleration, braking, or steering loss. The medical evidence did not convince the fact finder that POTS, a seizure, or another medical episode caused the crash. That point needs care. The case is not about mocking a medical condition. It is about what the evidence showed in this crash. The appellate court later held the conviction was supported. So the question narrowed. If the car was working, and the medical explanation did not carry the day, why was the accelerator down? There was another thing investigators had to sort out from the noise. A case like this produces easy stories. Social media turns people into villains before the evidence gets heard. Streaming documentaries turn legal evidence into arguments about who seems believable. But a court does not find someone guilty on vibes. The cleaner question was smaller. Could the state prove that this was not loss of control, not confusion, not a medical blackout, but a purposeful act behind the wheel? That is why the next evidence mattered so much. It gave the driving data a human context. The state did not just point to speed. It pointed to the relationship, to the hours before the crash, and to words the court heard from before that morning. Less than a month before the fatal crash, testimony described an argument involving Shirilla and Dominic Russo. The appellate opinion records testimony that Shirilla said, "I'm going to wreck this car right now." That sentence did not prove the case alone, but it changed the room around the evidence. Because now the judge was not only looking at a terrible impact, the judge was looking at a pattern the state argued made the impact purposeful. There was also the change in the death rulings. The manner of death was initially accident. Later, after more evidence, it was changed to homicide. That is a huge turn in any case. It means the official interpretation moved from tragedy to criminal act. And when the case reached trial, Shirilla waived a jury. A judge would hear the evidence. On August 14, 2023, Mackenzie Shirilla was found guilty. Murder, felonious assault, aggravated vehicular homicide, drug possession and possessing criminal tools. The drug evidence is easy to sensationalize, so it needs to stay in its lane. The appellate opinion supports psilocybin evidence. It also notes no alcohol detected. The point is not to invent intoxication where the opinion does not say it. The load-bearing evidence was the driving, the data, the reconstruction, the relationship evidence, and the judge's view of intent. That is why the verdict was so stark. A case that began in public as a crash ended in court as murder. The word accident did not survive the evidence. But the verdict was not the last fight. After conviction came the appeal. And the appeal matters because it is where a lot of online arguments should have been tested. Was the evidence enough? Did the medical theory create reasonable doubt? Did the vehicle evidence leave room for a different cause? The 8th District Court of Appeals affirmed the convictions in 2024. Then came a post-conviction petition. That did not reopen the case either. In 2026, the appellate court affirmed dismissal of that petition as untimely. The filing was treated as 1 day late under the rule the court applied. Local reporting later said the Ohio Supreme Court declined review. Until the official docket order is pulled, that stays reported, not overstated. That timeliness fight sounds technical, but it matters to the viewer for one reason. It shows where the case actually stands now. The internet can keep retrying the trial forever. The courts did not. The direct appeal was already affirmed. The later petition did not get the case reopened. The prison file still shows a life sentence with first parole eligibility in 2037. That does not mean every person watching has to feel the same way about a teenage defendant, a horrific crash, or the sentence that followed. It means the video has to be honest about the evidence. But the legal posture is clear enough for the main point. The conviction survived direct appeal. At sentencing, the judge imposed life with first parole eligibility after 15 years. The Ohio prison file lists an aggregate sentence of 15 years to life with parole eligibility in October 2037. That is the part a title cannot carry. 2 families lost Dominic Russo and Davion Flanagan. The courtroom footage shows people trying to survive the legal ending of something that had already ended their old lives. There is a line. True crime channels cross when they turn that into spectacle. This script is not going to do that. The useful question is narrower and colder. What did the proof show in the last seconds? Not the rumors. Not Netflix. Not the family drama that gets clipped because it is ugly. The proof. A car gaining speed. A throttle at 100%. No break in the window that mattered. A prior statement the court heard. A judge who found intent. An appeal that did not undo it. That is why 4.6 seconds became the center of the case. The crash happened fast. The case did not. It moved from road to hospital, from accident to homicide, from trial to appeal, from public argument to the prison file. And still, the most disturbing part is not the speed by itself. It is the absence. No break. At the exact moment when a crash should have become a fight to stop. Full case sources are in the description. I am Carson Morgan. For Unsolved Chronicles X, stay curious, stay safe.